Legal issues are, number one, was there a facilitation and assistance of a client in crime or fraud? Second, was it just incompetent? Third, was there a failure to exercise independent judgment and render candid advice to the client? In a couple minutes, we'll talk about historical matters and what you can do about it, but that's an outline of the discipline issues.
Hard to get credit. Okay, ethics, hard to get. So the next question is, if we can keep our remarks brief on this, we want to leave time for question and answer. And this is actually the last question that I'm going to ask is, what should be done to restore respect for the prohibition against torture?
Well, I've been very uncomfortable with all the announcements ahead of time about whether there should or shouldn't be prosecutions. I think that the President has potentially put things on the right track by telling the Justice Department to go ahead and investigate and figure out whether the facts, which are mostly, some are known, obviously there are many facts, and certainly the interactions among the people involved here are not mostly known to us anyway. And then the professional prosecutors ought to make a decision about whether there have been crimes committed, and if so, whether they can prove them in the traditional way. You know, I suppose when we see that report from the Justice Department, we'll get a little better idea of what some of the facts are. But there hasn't been a vigorous, total investigation. My own, the one response that I'm sure we ought to do, which is that we need to convince the rest of the world that this was aberrational, that this is not the way the United States looks at torture, that we really do believe in our traditional position of abhorring torture and trying to promote the international legal regime to stop it. And one thing we could do that's within our control would be to cut back on the reservations and understandings and other limitations that we put on our ratification of the Torture Convention. So one thing that gave John just a tiny little foothold was that the U.S. had narrowed down the definition of torture with an understanding, or purported to, when it ratified. And also the Senate had added a limitation on the prohibition on sending people off to be tortured in other countries. And so the Senate, or maybe Congress through a statute, could abandon or narrow down those reservations, understandings, declarations. And I think that would be at least one good way to tell the rest of the world that whether John Yoo and others get prosecuted for what they did, that it was a mistake, it was aberrational, and we're not going to do it again. And we're going to take the institutional steps we need to make sure it doesn't happen again.
In terms of, there's been a tremendous amount of discussion about the question of criminal accountability. I don't have a particularly strong view on whether there should or should not be, as a normative matter, criminal accountability. I think there are hard issues that are presented by that question. I simply would note that as a descriptive matter, there would be very, very significant challenges for any prosecutor who attempted to bring criminal charges either against the interrogators, if they in fact operated within the scope of the guidance that they got from OLC, or on the part of the lawyers. I think it would be very difficult to bring a case criminally in either of those circumstances. I think the interrogators would probably have the ability to rely on the common law doctrine of reasonable reliance. Right? They reasonably relied on what they thought was good faith advice from counsel. And on the question of what counsel's role is, I mean, this ties into a little bit of discussion that John had, and we can talk about this more. My own view, in fact, is that, of course, a lawyer is not held criminally responsible for giving legal advice on the application of a criminal statute that is wrong, right? That's not the test. And it's not even the question of whether he gave advice that he believed. I think many lawyers will frequently say, look, the better argument in this case is that it's impermissible, but here's an argument that can be made in favor of it, and I believe that that argument is a defensible argument, even though I believe it is more likely to lose than not. And I don't think a lawyer who gives that kind of advice has committed, has engaged in criminal conduct under the criminal statute, under the criminal cases that have been brought against lawyers for their involvement in common plan and purpose kinds of conspiracies. My own view ultimately is that the direction should be prospective, right? And that's why, as I adumbrated in my opening remarks, I think the key is to make sure, as John has said, that this doesn't happen anymore, right? Not only should we make the kind of signal to the world that this is not the way the United States behaves, but the most important thing is for presidents, Obama and future presidents, to deal with an issue which is very unclear. As a government lawyer, I can tell you the question of how far you can go in terms of advising your client. Is your answer to say, well, a legal argument can be advanced or not, or is your argument is your position to argue for the more plausible legal argument? This is a very unsettled thing. I worked in the government for 11 years, and every senior legal lawyer that I worked with had a different view on this. And so I think the way to deal with this going forward is for presidents to set a very clear policy that basically says they don't want their lawyers to be hired gunslingers. They want their lawyers to give them good advice to help them make good decisions that are consistent with not only the law, but also the policy and national interests of the United States.
Great. So going forward, I'm definitely not a criminal law professor, so I could speak with even less confidence about whether there's enough to actually prosecute any of the authors of these memos for any kind of inchoate criminal liability with respect to the torture. I do think investigation makes a lot of sense, given sort of how flagrant some of the stuff is in these memos, and I think what we learn from that investigation can be put to use, as you say, in clarifying what the role of lawyers is and what the role of government lawyers is. One thing that I think is really important for students to draw from this is that there's a lot of what this colleague of mine who teaches legal ethics calls lawyer exceptionalism in our profession when it comes to sort of what the responsibility of lawyers is as professionals when they advise their clients. So for instance, the SEC has tried to regulate or tried to sort of ramp up a little bit the responsibility of in-house counsel for potential securities fraud of their clients, and the bar just totally flipped out when the SEC tried to do that and talked about how, imposing this sort of responsibility would interfere with the trust between the client and the lawyer and all this other stuff. And I think, sort of getting rid of a little bit of that lawyer exceptionalism and maybe being open to raising the bar and raising the standard on the quality of the legal advice that's given would potentially be a really great first step. I know a number of people have called for sort of academic discipline. I hate to disappoint some of the people in the room, do actually share a lot of Dean Edley's concerns around academic freedom with academic university discipline. But I do think it's really important that all of you as students are pushing back, right? Like holding this event, I think helps remove some of the imprimatur that being a tenured professor at the University of California has and sort of indicates to the world that you don't agree with these memos, you don't think that they were the right thing to do, you reject them. I think directly, this is kind of a hard thing to ask students to do, but I think direct inquiries to your professor about what was going on and how he came up with these memos, I think that that's appropriate, right? That doesn't bear the same risks to academic freedom that formal university inquiries would bear. And so I think a lot of what you guys are doing is actually a great way to sort of remove any kind of implicit imprimatur that people might think stems from Professor Yu being a professor at the University of California, understanding that there is some kind of feedback. But I do agree that some kind of clarifying rules going forward on the standards that government lawyers, at least government lawyers, if not all lawyers, should be living up to when they advise their clients on potentially criminal conduct would be really helpful.
And so in terms of the legal ethics piece, again, I'm not a criminal law specialist. When I called for putting the lawyer's behavior to the test, I think the DOJ report, I have my fingers crossed, hopefully that will be a terrific exercise in doing just that. It's an odd historical quirk that the DOJ says it has no power to do anything more than write a report once the lawyer has left the DOJ. But that's the kind of investigation I'm talking about. For the students, just a few thoughts. Number one is understand this phenomenon of moral panics. I think there was a panic in insular decision making. I think they were under psychological pressures and in an insular setting that led to some really bad decision making, even counterproductive to their own state.